To speak louder, right? Okay. Ah, very good. Okay. Okay. Just so you know, I just want to let you know, we invite them to say their name, and I will ask them to spell it too, but they don't have to. As a matter of fact, it's against the law to ask them to. So we just invite them to, and I'll ask them to spell it for you as well. But don't worry if they don't do it.
So you understand?
Yeah, sure. Sure, okay. Yeah, thank you. Okay, with the commission seated and a quorum present, we'll continue on with the meeting. Thanks to the thoroughness of the executive director's report, we've almost knocked out governance issues completely. So this is fantastic. We're getting 2 for 1 here this morning. And I'd like to turn it over to the vice chair, who, as I understand, had considered some of these feedback items per the executive director's request, and she'll bring us up to speed.
Thank you, Commissioner Ward. You began to introduce one of the items that I'd like to come to some agreement on as a commission, and that was regarding a baseline protocol for turnaround time between commissioner and staff communications and requests. And so the goal here is not to say staff hasn't been doing their job and hasn't been responsive. It's we want you to have a sense of how quickly you can expect for us to respond to your requests and vice versa. And so the suggestion was made as a 24-hour turnaround time, and that we institute that email communication is the main mode of communication. Of course, there will be exceptions to that, but in terms of allowing us a system to be able to track and staff, giving them, I think, a little more flexibility on how to manage the influx of communication. So my suggestion for conversation purposes would be, does 24 hours seem reasonable as an expectation, mutual expectation between commissioners and staff? Commissioner Yao.
Unless it's advantageous to do so, don't just respond to all. Just most of the time, just respond directly to the executive director. But if there are information that you feel it's advantageous to share with all the other commissioners, then do it response to all.
Mm-hmm. One clarification point, too. This doesn't mean we expect that staff will have the answers to all of our questions within 24 hours, but that you will acknowledge receipt and next steps.
Absolutely. And we were actually hoping that we were responding much more quickly than that, and in most cases, that's what we try to do. I would ask everyone when we're looking at Gmail, because this has been the biggest problem we've had, is to expand, every time you get a response, expand that entire email list so that you see whether or not there's a response in there somewhere. And I know that the Gmail shows you what's been opened and hasn't, but it has been, for me, on several occasions, I've missed a comment from someone because it's in the middle of a 17-string email. And so the other thing I would ask is that if you have something that's very urgent that we need to address right now, make it a new message, and that way the expansion issue doesn't become an issue. Thank you.
Great. So, seeing no concerns, disagreement, 24 hours is our protocol for commissioner staff communication and requests, and we will be relying on email as the primary mode of communication. The second point, governance point, that I wanted to bring up to the Commission for full discussion is in regards to our chair and vice chair responsibilities and protocol for developing agendas for our meetings. Of course, our intent in establishing a rotating chair, vice chair structure was that we would not only be a well-oiled machine, but that we would be a multi-partisan machine, that we would be a collaborative machine. I think that as we've been testing out the system, a few issues have come to light that we could easily address, and that is really regarding chain of command and division of responsibilities and timeline on how to get a comprehensive supplemental agenda out to folks in advance of the meetings. Now, we, of course, have been posting our broad agenda with our 14-day meeting notice, but what we've been attempting to do is to create a supplemental agenda or an expansion, in effect, where we're able to put much more detail, even some timing as to the order of business that will be taking place in any given meeting. I think the tricky part has been when multiple commissioners have suggestions for those agendas. Where do those suggestions go? By when do they need to come in order for us to really be able to turn around an agenda in a way that makes sense? Having just recently been through this process as vice chair and Commissioner Ward as chair, we wanted to put out a suggested timeline, which I did speak with Mr. Claypool regarding to see if this would work. The suggestion is that we have a 72-hour previous to our meeting time deadline for all commissioners to get in their suggested agenda items. The agenda items as suggested would go to the chair for that meeting. Then the chair, by 48 hours prior to the meeting, locks in the agenda. That is the agenda that staff works with. That's the agenda that gets posted, the detailed agenda. Recognizing that later down the road, as our work picks up, we may need to compress this and say that it's a 48-hour deadline and a 24-hour deadline, but for now it seems like 72 and 48 could work. Let me just run down what that would look like for Sacramento, which is the meeting that I would be chairing. So we're scheduled to start meeting on Wednesday morning, I believe at 9 o'clock with our subcommittee meetings. So Sunday morning at 9 o'clock would be the deadline for which commissioners would send any suggested agenda items to myself. I would then, over the next 24 hours, work with Commissioner Filkins-Weber, or we probably would have been in some communication even before that regarding the agenda. And so 48 hours prior to the meeting, which would be Monday morning, you could expect that you would have an agenda to review. And that would also give a couple days worth of time where you could have the opportunity to prep before a meeting, which is really our intention as well. That's my thought around that, and just wanted to put it out to the full commission for discussion. Hopefully we can come out with some protocol.
Question? Mm-hmm. This also includes the subcommittee agendas.
Yes, because it would be for the full agenda.
For the full agenda. So also the details of the subcommittee would have the same notice. Okay.
Mm-hmm. Mm-hmm.
While we're discussing the agenda, I'd like also to throw up this concept of any agenda item that involves a lot of public participation. We should try to define the timeline for that and not allow the previous agenda overrunning and delaying that particular item, because a lot of public come into the meeting with the intent of addressing us on that particular item, and often when we overrun our schedule, we basically cause them to either miss it entirely because they can't allocate sufficient time to wait for us to finish. But doing so probably would force us to table whatever unfinished business we have from the previous item until a later time. So I don't know whether you want to have a little bit of discussion as to whether we want to perhaps implement something like that in the interest of allowing the public to address us in a more timely manner.
I just want to say I think that's an excellent suggestion, and so I think we would indicate if you're submitting an item for an agenda and you think there's going to be substantial public comment on it to note, but otherwise that I would expect the chair and the vice chair to define a period for public comment, and so that can be noted on the agenda and maybe kind of called out for the public.
I thought it might be helpful, just one note of clarification. Please keep in mind when thinking about agenda items that in our 14-day notice we have to give the public reasonable guidance about the topics that will be discussed. we can fine-tune how those slot in under that agenda, but it's not possible a few days before a meeting to add a whole new agenda item that's not already covered in the public notice.
Definitely. I had requested for staff to have copies of the Sacramento agenda. Do we have those available now, or we'll get them later in the day?
I'm fairly certain that Janice had actually printed those, but she's out right now printing a different item. It may be right here. So
it's been posted on the website
been
already.
Posted on the web. So that would be for Sacramento, for example. Then that agenda already provides the parameters of what types of expansions you can add into the agenda. It would not go outside of what has already been noticed, but it would provide a greater level of detail.
I'd just like to submit that, as commissioners, again, we all own the process of setting the agenda and things like that, and it really is the chair and vice chair's job, along with staff, to set that agenda and put it together. And so, any comments, I would say, get to them, and they'll figure out whether or not it fits and where to fit it and everything else. But bring the feedback. Let's just observe. Unless there's guys otherwise, the recommended time frames so that everybody can do their job. And I think another thing along the lines of that is if beyond just agenda items to the chair and vice chair or to staff, I think that if there's guest speakers or someone that comes up to you and wants to address the commission, things like that, it would be rather than just inviting them to come and do it, if it's someone you know, someone you work with, something like that, and they have an area of expertise that they wish to share, perhaps we should forward that to the staff or chair or vice chair for consideration of allocating time or something like that. We've run into times, as we all know, in the past where people with said expertise are invited to come and address the commission at open session, and so they come prepared with a 15-minute presentation, which really isn't fair to the public for others that have come to give comment in just a small amount of time. To have that time eaten up by one person as opposed to giving the equal time to everybody seems like it could get us into trouble down the road. So that's just a suggestion I have. From my end. Mr. Claypool, did you have a comment on that?
Well, not actually a comment on that, because all of these are great suggestions, but I just wanted to step back to the original idea that Commissioner Galamos-Malloy had propositioned as far as the 48-hour and then the 24-hour period between there, where we solidified that the final items between the vice chair and the chair. And I would hope that we would actually have that 24-hour period. I think was what we were originally discussed, was having that be the time that staff needed to ensure that it was run by the chief counsel, and then we had time to get it up on our website. Now, the only reason we need a 24-hour period, so we're talking about 3 days, 72 hours. The only reason we currently need a 24-hour period for that is because we're working through the Secretary of State's office. And if we get the changes at 7 o'clock at night, the very earliest we will see anybody is 12 o'clock the next day. And then I don't know how long it will take them to post it up. Once we have control of our own website, we can certainly shorten that time period to be, say, 12 hours or whatever it is. But we have to be aware that the staff to do this will have to be available. And so we need the 48 hours as a final deadline, and then some period of time, currently I would suggest 24 hours, to make sure that we can get it up. So we're really talking at this point about a 3-day, no other changes beyond that unless they're absolutely essential. And if that were the case, then we would be going out to all staff or all the commissioners on a different basis anyway.
Any comment on this matter before we leave it? Excellent. Very good. All right. Looking forward here to our very first subcommittee report to the full commission. And I think when we drew straws, the legal's up first.
Thank you, Chair. In the legal subcommittee, we had an opportunity to prioritize various issues, approximately 8, and given the limited amount of time, we did not have an opportunity to address all of them. Therefore, we prioritized. First, we discussed VRA Council and the issues surrounding the necessity to identify an individual. And just in summary, we charged Kirk Miller to solicit presentation materials from a number of specifically named attorneys. The names of those attorneys will be provided by Maria Blanco and I believe Commissioner Anchetta, just as a starting point. We've also asked Mr. Miller to contact the Department of Justice, as we had discussed the possibility that there may be individuals in the Department of Justice that might very well be interested in this position as our VRA counsel. We've also discussed and asked Mr. Miller to draft the proposed notice that would be placed on the website for this position. And I believe Commissioner Blanco will also provide Mr. Miller locations for other places where announcements can be posted for this position. We have also considered the possibility of coming together again around March 4th in a legal subcommittee special meeting, subject to change and subject to further detail, but so that we can determine the status of the identity of potential individuals. And the reason that we did this is because apparently from the experience that we have in the legal subcommittee from Commissioner Anchetta's participation and Commissioner Blanco, the limited number of people that might be qualified for this position, and we discussed the possibility of really opening this up nationwide because it's not a California issue, it's a federal law issue. So we certainly would not be bound by a particular California attorney potentially in that regard. Once we also discussed the possibilities of retainers versus hourly. That went around for a while, but what we've agreed on is more than likely that the individual that would be considered for this position will present their ideas, and so we might very well get various options for how the attorney could present their consultation services to this commission, and whether it would be a staff position, retainer position, or might very well be that they have an entirely different idea that we hadn't considered. So we haven't narrowed that idea yet. We will limit it. I mean, we'll take a look at what presentation we can get from the legal subcommittee. So we are moving forward on that. We're moving forward quickly, and so more than likely we should have some information by our special session tentatively set for March 4th. The next item that we discussed was Bagley-Keene training and Public Records Act training. We discussed the necessity that at this point, given our structure and structure of governance that we've elected, in particular subcommittees, that the prior training that we received, the first 8 in particular from the BSA, and in fact I believe Ms. Neville's from the Bureau of State Audits also provided the training for the 6 in January. That was a general overall training for Bagley-Keene issues, and so we are considering one further session of training for the full commission for the sole purpose of having it tailored in its presentation of Bagley-Keene for our present structure, involving the subcommittees, involving some IT issues. And as I didn't note here, but I think we've agreed as well that we will coordinate the Public Records Act training. So if possible, we either have multiple individuals, but Mr. Miller will be looking into that and identifying an individual to come and give us training. And again, it may seem duplicative of what we've had before, but we're not intending to do that. We really want to tailor it to our structure and tailor it for the issues that we've seen come up time and time again. And if it's possible, we could consider Donna Neville's again, or maybe somebody else that Mr. Miller, and if nobody else, maybe Mr. Miller himself. So we'll consider that. So we discussed that. We also discussed something of interest that this commission mentioned at the last full meeting, which was Section 8253 of the Government Code. And as you will recall, Section 8253 had a provision in there prohibiting communications with and receiving communication from the public regarding, quote, redistricting matters, close quote. And what does that mean? So we actually received very interesting public comment on this issue and was most appreciative of the suggestions that were made by the public. For instance, given that we are dealing with a law that does not have any judicial interpretation, some of the members of the public had suggested to narrowly define what quote-unquote redistricting matters mean. And maybe if we narrowly defined it to simply information of drawing lines on a map, it may free up our concerns anyway of going to events where we are being asked to speak. And then, but overall, regarding some of the other issues that have come up, we've asked Mr. Miller and he has taken it under advisement regarding. We discussed the full issue, essentially, and he understands the issue, and he will be reporting back to us for a full discussion of the issue and to further advise this commission regarding his recommendations on participation, such as what you've done in the past. Many of you have given welcoming comments and then felt obligated to leave some meetings where there were redistricting issues presented. And so that issue was fully discussed and presented to Mr. Miller, and he will get back to the legal subcommittee, and we will present it to the full commission as to what his recommendations will be regarding your participation in meetings, including webinars. I mean, there will be so many redistricting functions throughout the United States. And obviously we will likely continue to get invitations in that regard, and we want to clarify that issue, and Mr. Miller will assist us, and we will get you that answer. And then the last item we discussed in legal subcommittee, but we did not have an opportunity to flesh out entirely, and we will take it up in our next legal subcommittee, is the idea of some standing committee rules for essentially governance. Again, we discussed the fact that this commission had previously voted on January 13th to limit public comment to 5 minutes. And again, we did that for the purpose of allowing more participation by the public. It's certainly not a circumstance where we were limiting the public comment. We really want to hear from a variety of individuals. So we briefly discussed some of those rules and one other factor of some other additions that we will make to the agenda, but we'll probably come back to that issue and be able to present more recommendations to the full commission following our next legal subcommittee. And that's all the legal advisory committee has to report, unless my other fellow commission members would like to add anything.
It's just to mention some other things that we talked about in terms of the hiring of the voting rights attorney. We also discussed the possibility of a pool in academia, that there might be, that could be another place where we could look, would be among law professors in particular who focus on the Voting Rights Act. So, you know, again, with the knowledge that this is a limited community of folks who do this, and that we have to deal with issues of perceptions of partiality and bias, we were really trying to think of where can we go. So academia, in addition to Department of Justice. And then we discussed a little bit what the functions, why we thought this was such an important position to fill quickly, even though some of the decision making is, around drawing maps may come a little later. We thought that we discussed the fact that this person could even train the commission on things that we need to be able to make sure we solicit in the public comment, because there are elements that have to go into the consideration of the record when you do present. We will have to do a report, and that report has to explain certain decisions we made, and that means that we have to be able to get that information when we do our public meetings, and that would be the kind of thing that the attorney could train us, and that was part of the discussion about why we need to start sooner rather than later, and that even identifying legal concerns about the outreach meetings, how we handle discussions of race, etc. So it's just to add that we really began the process of trying to define what the attorney has to do for us and why we felt it was urgent that we move forward as quickly as possible.
Along the same lines, we also considered that we're really looking at two different attorneys, one that would carry us through the August 15th date, and then the idea if we have to defend any of these maps, that's a whole separate issue.
I just wanted to comment quickly on Commissioner Blanco's recognition of the importance of the VRA expert in terms of the outreach too, and I think for both we'll talk later on, but the Technical and Outreach Commission sees them and playing an integral role in developing everything from developing materials to how the meetings are going to be structured. So as soon as that was one of our points in terms of getting them on board as soon as possible, because any consultants that we use, whether it be technical or project management, are going to need to have the input of the VRA expert as soon as possible.
That's really great to know. Yeah.
Did you want to go ahead? Sorry. Jody, did your subcommittee discuss, and I'm not even sure if this applies or not, the ex post facto rules that might be in part of this process? For example, when we start the public testimony meetings where we're talking about mapping, and if we have 9 commissioners or 10 commissioners there, the other 2 or 1, would they be able to participate in the drawing of maps at some subsequent date?
I do recall your suggestion in that regard, and given the limited amount of time, we had bullet points of various issues which included that issue, and I'm afraid we did not have an opportunity to get to it based on our priority to consider VRA council. So what I can do is add it to our agenda for next occasion. And so can you clarify, you're talking about, just state your issue again so I can make sure I understand it properly.
If we have a formal hearing, say, to discuss a trial map in Riverside, and not all of the commissioners are able to attend, let's say 10 of them are present and 4 are absent, when the final decision is made in August to draw the final map, because the other 2 or 3 were not present, are they able to participate in making that final decision?
Got it. Thank you.
I just wanted to flag an issue that I raised, actually more as a public comment yesterday. I wasn't sworn yet, but one issue that I wanted to flag for the full commission, and in particular the technical committee, is that in order to look at Voting Rights Act compliance, in addition to the attorney, we're going to need some sort of social science expertise that will enable us to look at certain kinds of data, which actually are rather hard to get. It's not census data, it's not PL 94 or ACS data. It's data that revolves around political behavior in particular areas where there might be majority-minority districts. Because part of what's going on with Section 2 compliance is that we're trying to anticipate where we might get sued if we don't draw a particular set of lines a certain way. We're going to have to ultimately deal with a rather sparse data set, unfortunately, which is looking at minority voting behavior, racially polarized vote, so non-minority voting behavior against minority candidates, for example. That data is often not generated unless you're litigating. So it's a very tricky problem for us to figure out, well, are we just going to look at the racial numbers or the ethnic numbers, or are we going to look at some other data that will help us inform whether there's a potential Section 2 violation? We need to have that capacity at some level. I think it's going to be very difficult, if not impossible, to actually try to generate that data internally. We may have to rely on whatever data is presented to us by the public or by particular groups, but we need to have at least the expertise to analyze what is available at the time. So I would simply add that as a capacity that the commission and or staff needs to develop in addition to the attorney for Voting Rights Act compliance.
Since this is the first occasion in which we have a report from our subcommittee, I appreciate Commissioner Ontai's suggestion regarding the possibility of issues that should be discussed in the legal subcommittee. Would the Commission agree that at the time that a subcommittee is reporting, that this would be an occasion in which other Commission members could raise issues that should be brought to the subcommittee, so that then the next occasion that we have our meeting or when we need to clarify further agenda issues, that we can make sure that it's properly noticed, properly noticed, and then we are actually fulfilling all of your inquiries for the tasks that you would then assign to the subcommittee. So if everybody seems to be shaking their head in agreement, does anyone else, other than Commissioner Ontai, have some suggestions for legal subcommittee's consideration at our next meeting or next properly noticed meeting if it's not already on our agenda?
One of the things that I was going to try and raise late this afternoon, and I'm not sure if this falls in your category, but let me throw it out there, is in trying to structure some of these outreach meetings, and the question has been raised by commissioners as well, is what boundaries do the commissioners have in terms of responding to during a public input hearing? Do the commissioners, or are they allowed to be able to interact with the public? We've talked to some of the potential consultants, and they want to know if they have what their role is in terms of interacting with the public. Where will that dynamic take place? And if you could look into that legally, that would be helpful.
Just responding to Jody's comment in terms of the request of subcommittees consideration, I think we probably should do that offline as compared to doing it in this complete meeting. I think we should limit this meeting to issues that has been discussed by the subcommittee so that we can kind of carry on an in-depth discussion. In terms of special topic or additional topic to be considered, I think we probably can do best by just doing it offline communication, either between two individuals, so that we don't take up too much time in dealing with that in the formal session.
The only hesitation I would have in that regard is whether or not the issue that's presented is appropriate for the subcommittee. For instance, if Mr. Miller feels that a question that's being presented to legal is something that he should take on his own and should not be discussed necessarily in an open subcommittee, it's something that could be flushed out here rather than overly burdening a subcommittee with communications that are ongoing elsewhere. Or offline, I mean. But.
I would concur with what Commissioner Filkins-Weber has commented on. I have an issue that I would like to present for consideration by the Legal Commission, and that would be the elements of what would, I guess, for lack of a better way to express it, legally defensible maps. Ongoing, we've had discussions and suggestions from the public and others that we are going to be challenged in court. And I understand that if we meet the mandates of Prop 11, that if we have a process that is inclusive of the public, if we have a process that incorporates and considers input from the public, and if we have a process that is in deciding on the map drawing that is reasonable and rational, that we're going to come up with a product that reflects the wishes of the California population, right? But even then, we stand to be challenged in court. So for me, even though we meet all of those requirements, what are other considerations in terms of perhaps things that we should consider, as has been brought up, and that we should be careful about in conducting outreach meetings, in comments that we make about racial and ethnic groups, all of those things that we're going to get training on, hopefully, but still the issue is, how how can we anticipate some of the arguments that are going to be made against the maps as we present them, and how can we prepare for that? And I think being cognizant of that will help us as we carry on this process.
Just one comment in that regard, and I think you've made my point precisely, Commissioner Aguirre. This issue and what you raise, I think, is an example of what specifically needs to be addressed by our VRA Council, and may not necessarily be appropriate. It may be in a discussion for legal subcommittee, but I think that this might, and it might come about that if we know that commission members have issues that may not be appropriately addressed, or VRA Council wants to flush it out. But at this point, I don't want to step on VRA Council's toes. What you raise is a significant issue, and I really would not want to impose on our council. So I am taking it down. I just don't know that it's appropriate for legal subcommittee to consider this, because we would definitely need VRA's input, and maybe it might be something that the attorney themselves would wish to draft and present as a training to the full commission, and not necessarily just limited to subcommittee, because this issue is very important for all of our work. So, but I am taking it down, and I'm sure our VRA Council will be in our legal subcommittee, so we'll get to it. That's for sure. I just don't know that we can agendize this for our next legal subcommittee without VRA Council.
And I would appreciate that comment. My intent on a more general level was to raise it to the attention of the full commission as something that we need to prepare for.
And I would just, like to go back to Commissioner Yao's suggestion, and I understand that sometimes we may have time constraints, but I find that this is a very helpful process to not only have the subcommittees reporting to us, but to also get feedback. I think having been in a position where there's just two people working, you can make some progress, but you are limited in terms of getting direction, and that has to come from the commission. And I've also recognized that these subcommittees don't work in isolation, that they all overlap, and this is a great opportunity for us to hash those things out in a more communal way. So again, while respecting the time constraints, I think it's helpful for us to have this discussion, the feedback in two ways.
That's an excellent point, and exactly right, as we understood the subcommittee structure to allot for. We all go into our individual specialty groups and come up with issues that we identify, technical and outreach. As I understood, the technical committee sat in an outreach meeting, the outreach committee sat in on the technical subcommittee meeting, because their issues overlapped so closely and intermarried. So the point in bringing these reports to the main commission is so that full discussion on each of these items is available in a coordinated and limited amount of time. I had a question regarding your VRA ideas, and I'm wondering if at an earlier date we had discussed considering 2 VRA lawyers. Is that something that you guys discussed in the subcommittee? And if not, is it something you're willing to discuss?
No. I can start with that. I'm not sure that we specifically discussed 2 attorneys. We did discuss how important it would be for whoever we hired to withstand scrutiny in terms of bias, perceived bias. And we all agreed that that's a big concern and also a problematic one, because this is a field where you have well-defined plaintiffs' attorneys and well-defined defense attorneys. It's not a field where you have people that go do both sides as sort of, it's really kind of, you represent defendants or you represent plaintiffs in voting rights cases. And so we know that's a big challenge. So which is one of the reasons we started talking about looking at universities, at Department of Justice, maybe state AGs. And in that conversation, we just briefly said, we might have to have 2, but it wasn't a specific discussion. It was more about us recognizing the difficulty in finding someone who will be perceived as impartial.
And one further note in that regard, I think it's going to come down to the response that we get from potential candidates. And so if we find somebody, obviously that might come from the Department of Justice who's completely neutral in our assessment and unbiased, then we don't even need to get to the discussion of two. So I think it's really going to be dependent upon who responds to our solicitation.
Commissioner Ward, I wanted to comment on Commissioner Aguirre's point. And make a suggestion. I think that as much as we want to really move quickly on hiring a voting rights attorney, it may take a while because of the problems we've just identified. And we will be moving, we might be holding some hearings, and we'll definitely be conducting our own business, before we do that hire. And maybe, we could work with Mr. Miller to begin to at least take a look at some of the law that the legal committee could, so that while we're waiting, we aren't just navigating without any guidance. And I don't know how other commissioners feel about that, but I would like to hear if commissioners would be willing to have the legal committee work with our council in the meantime to figure out if there is something we need to do some at least initial training for the commissioners.
So I just wanted to respond to that. I think that's a great idea, and we obviously have your expertise and Commissioner Anchetta's expertise, so we should certainly take advantage of that in parallel as we are conducting a search.
Yeah, legal training was an agendized item for all subcommittees, so identifying areas of training for the commission at large is absolutely one of the things we're hoping that the subcommittees can identify and work with staff to arrange and accomplish as they come up. Any other questions for the legal subcommittee? Comments? Okay. Mr. Miller, you have opportunity now to address the commission. I'll make a statement real quick. My understanding is that the public comments for the subcommittees was available during the subcommittee meetings yesterday, and that we are going to offer public comments in the morning and before close of session this evening. So if public comments on this discussion will be able to be made, we have it at the agendized time at approximately 5:30 this evening or at the end of session.
I'm not sure that's really appropriate. I think during the subject matter is more appropriate. But if you want to miss the opportunity, then go ahead.
Certainly don't want to miss the opportunity. That's why we're going to provide a period of time at the beginning of every session, at the end of every session for public comment. And I also encourage you, I know you've been diligent at being here and at our subcommittee meetings, and you've just been a great source of comment for us. And there's if you're not able to stay till the agendized time for public comments, then I encourage you to please put them in writing and submit them to us through the website, or we can call and make those. But the problem is, if we open this time up for public comments, we'll never get through the agenda. So that's why we have to, unfortunately, organize them. Thank you so much. I appreciate that. Thank you. Mr. Miller.
I think that that was an excellent and in-depth summary of our meeting, and as such, I have no color commentary to add.
Fantastic. 11:30. Next up was the technical subcommittee. But I'd like to propose that we go to communications if Pardon?
I had a misunderstanding regarding the agenda as well.
Is it not Finance and Administration Subcommittee was actually scheduled for before lunch?
Yesterday we discussed switching legal and finance due to this finance subcommittee's recommendation that because so much of their agendas depends on what the other subcommittees came up with, it made sense to move them to the end of the slate. But due to trying to push the agenda forward as much as possible, it seems like moving to communications might be an appropriate thing to do.
The only other question that I had, Chairman, you had postponed from Thursday item M, which was training, and so I thought we were under the impression that Mr. Miller, if I thought this was his area, we were just going to throw it under the legal. But unless you had some other idea of where M was going to go, since you postponed it from yesterday.
That was my understanding too, Mr. Miller. I thought was satisfied with the Bagley-Keene discussion. Did you have further Bagley-Keene comments to make, Mr. Miller?
Well, there's always the potential for further comment.
Okay, great, fantastic.
Having said that, while it looks like a short and straightforward act, and it's sort of like Bible verses where the minister continues to refer back to that short phrase with additional insight every time. That said, I think in light of our decision to have a more fulsome training at the next commission meeting and where we are in the agenda, it makes sense just to hold that for now and try to do it in a comprehensive way at our next meeting.
Thank you, Mr. Miller. Did the commission at large have any comments about Bagley-Keene, or we were going to kind of lump in the rest of training towards the end of Saturday, since we are going to be short on commissioners? Did you have anything additional?
Oh, I'm sorry. Are we done with item M? Are you considering that finished? Otherwise, I had a question.
Go for it.
Okay.
We'll tackle item M at this point.
When you put down here the sexual harassment and the ethics training, did you have any idea? Frankly, I would like to be refreshed regarding our obligations. I thought that there was some time limitations for the commission members to complete that, or at least there was some suggestion. Well, the 6 months on the ethics, but was there something else on the sexual harassment? And in other words, what else could we, just refreshing our recollection regarding the necessity for those obligations. I'm assuming that's why it was on the agenda, and if just further clarification if there was a time limit on sexual harassment like it was with ethics.
Mr. Claypool's been tackling and running this issue down for us diligently, so I'll pass the mic to him.
Yes, and actually that item was placed on because I wanted to just give you an update on where we're at. The Secretary of State continues to try to get that sexual harassment training. Yes, there is a time limit on it. I believe it is less than the time limit for the ethics training, but I don't have that date in front of me. I don't believe we have passed it as a commission. But the Secretary of State is still trying to decide whether she can offer it online or whether we're going to need to have it in person. Originally, I believe Mr. Russo from this Bureau of State Audits had said that it needed to be an in-person instruction. I do not believe that that's the case with the Secretary of State's office.
Yeah, just to clarify, my recollection is that Mr. Russo had suggested that it be in person just to make sure. I think it was more a compliance issue if we have the full commission here and take them away for an hour and do the training to make sure everyone actually had it.
It was just more efficient for time if we had one person address the full commission, then everybody completed that obligation. So.
Well, I believe the Secretary of State's approach is to simply put it online because it's going to be easier for them to line that person up. And I think we're close to getting it online, and then we'll probably have a check-in so each of you will make sure that everyone gets that training.
Is that a part of the ethics training to see if we actually do the training?
It can look that way, can it? Thank you.
I'm aware that there are a number of law firms locally in this area that provides these kind of training on a regular basis. Would you like me to pursue it and see if we can squeeze that in before we convene Saturday? If you'd like to wait and that will be fine. But if you want to accelerate that, I can certainly make a few phone calls and try to make that happen either today or tomorrow.
Are there special credentials required, does staff know, for what would be a trainer for sexual harassment and ethics at the government level?
I don't know whether there are. I would automatically assume that someone would have to have some facility in providing those types of services. I don't think that it would that would hurt us if that were a possibility, but that's a commission decision. The Secretary of State again has been working on it, and clearly they have a lot of other things to do. So if it went off their radar, I'm sure that wouldn't be something that would bother them. But I don't know how quickly someone could put that together. That's all.
I just wanted to clarify for purposes of the agendas that we've been working with. We had a discussion item related to trainings posted. I don't believe we had given public notice that we were going to actually have a training. Is that correct? Would we run into any issues there?
While we're looking that up, I don't think we should do something quickly, just find somebody here and do it here, even if we were okay with notice. I think there are particular issues around being a state body, and the kinds of issues that are we're not the normal employer-employee situation that most of these trainings are geared to, having done them for many years myself. This is, I think, slightly different. So, and the questions, there's just all kinds of technical things about definitions that would be very tailored to this body. So I would suggest that we not try and do something right now.
I agree. I would like to see the Secretary of State's already underway, and if they're so close to getting it up on the web, that would be great.
We will speak with Ms. Mejia with the Secretary of State's office, and Kirk is going to work with us to just make sure we understand the exact requirements for it, and so that we meet them.
Let's go ahead and move on to item N and approval of meeting minutes, remaining meeting minutes outstanding. I understand last session we had tabled that to give commissioners a full opportunity to review the record. Is wondering if there's any comments about those at this time, or if we're ready to move forward and approve those minutes.
I do have a question. Mr. Claypool, you had mentioned that, if I'm not mistaken, there was some public comment regarding the discrepancies in the minutes, and you had made comments earlier that you reviewed, or you or staff had reviewed the video to make clarification regarding certain comments. I think the confusion was between Commissioner Ryan and myself, and I was wondering, was that what you were referring to, that particular public comment that questioned those inconsistencies?
No, actually, the confusion was between the transcripts and the what was printed in them, and we had the transcripts changed to reflect what had actually happened. So we went to the audio and the video and made sure that we had the right person referenced in the transcripts. It wasn't with the minutes.
And so were the minutes corrected, though, or the minutes were correct in accordance with the video? So the public comment that was made seeking corrections of the minutes were not accurate because the transcript wasn't accurate.
Yes, and if I said the minutes and I was incorrect, I was referring to the transcripts, and that there was a discrepancy between the transcripts as to who had an attribution, and we have corrected that. But there were no discrepancies with the minutes.
Okay, so the individual who made the public comment could be assured that the minutes accurately reflect the video because his reliance on the transcript has since been corrected.
Yes.
Thank you. Let's move to approve.
Motion to approve minutes?
Move to approve.
Second.
Okay. Excellent.
Could you specifically spell out which minutes we're approving for the record?
These would be the minutes from November 30th, December 1st, December 10th, and December 15th of 2010.
At this time, is there any public comment regarding the approval of the meeting minutes from the time periods listed? If so, please come to the mic. Fantastic. Seeing nobody approaching the microphone, let's go ahead and take a voice vote. All in favor of approving the minutes listed, say aye. Aye. Very good. And all opposed, say no. And any abstentions?
Yes, I wasn't in attendance for some of those meetings, so I'll abstain.
So noted. Thank you.
I'm also abstaining.
And I'm abstaining as well.
I'm abstaining for the same reason as well.
Very good. Thank you.
Chairman, could we have just clarification on who moved? Who?
I moved, and Commissioner Malloy seconded.
And then to make sure we have the abstentions.
And just to clarify for the public, these minutes, this was 2010, and thus we were not seated as a full commission, and thus you note so many absences from that vote.
Okay, pushing forward. Does the panel have? I'd hate to cut communications short on time.
There's one more action item under your agenda, which is whether we, as a commission, agree that we will not do minutes moving forward, and instead, and this is relevant to the communications committee here, is to try to do a wrap up a daily wrap up at the end of the day with for our accomplishments, decisions, actions. So that and have that posted on a regular basis, given that we have a full, live streaming and we have transcripts and we have all that this is an additional burden on staff.
Make excellent talking points too when we communicate.
Any comments about ceasing to provide minutes since transcripts and video are present?
I would simply agree.
Do I hear a motion?
I would like to move that we not do formal meeting minutes moving forward.
Okay. Motion on the floor. Comment?
I'll second.
Okay, there's a motion on the floor to take a vote to cease providing meeting minutes in lieu of certified transcripts and video being available on the website. Comment?
Ask a question of clarification. Moving forward from this date, the date that we just approved, from December 15th, moving forward?
Yes, moving. In other words, no more formal meeting minutes other than the one we just approved.
Okay, thank you.
I think it would be good to be able to capture all the decisions that we make. And a minute is such a vehicle. A minute is not a duplicate of the transcript nor a duplicate of the video, but a vehicle to capture whether we approve or disapprove all the decisions during that period of time. Lacking that, we basically have to go back to the transcript to some other vehicle in order to recover those kind of decisions. I just want to make sure that when we decide to do away with the minute, we're okay in terms of using the transcript or other vehicles to recall the decisions that we make. So that's I on a personal basis don't have any issue with that, but lacking the summary of decisions could be problematic in the long run.
If I may intercede really quickly, I think one thing that would be just to organize this discussion to do is determine whether or not official minutes are something we want to continue with, and then bearing the result of that conversation, we can discuss things such as a meeting wrap-up that staff would be able to update accomplishments from each meeting or things like that on the site. So we can discuss other vehicles to perhaps provide that of a less burdensome nature. But if we can continue with the discussion of whether or not we want to continue to provide official meeting minutes and determine that, we can move on from there. Is that fair?
Just to clarify, Commissioner Yao, this is what I was saying, that the Public Information Committee already discussed less burdensome ways of doing exactly what you said, so which I'd be happy to allow our Communications Director to go into when we do the committee report.
If that's going to be discussed, then can we wait until we hear what the suggestions are? Because I share a similar concern about not having about the importance of capturing decisions in a ready form, in an accessible format before you come to the meeting, et cetera. So I'd like to hear what's been suggested before I do away with the minutes.
And I just want to echo what Commissioner Yao said. When I said they make excellent talking points, I had it in reverse order. I thought we were discussing maintaining either minutes or some form of wrap-up. So I'm pleased with either one because I don't want to be caught off guard in the public and not have those talking points available, freshly available from some form of summary.
So we have a motion on the floor and it was seconded, and I'm hearing a desire to table that motion until after the Communications Subcommittee is presented. Can I hear that motion?
Second.
Any seconds? Okay. So the motion on the floor is to table the motion to reconsider providing meeting minutes, official meeting minutes, on the website until after the subcommittees have been able to brief and alternative vehicles are discussed. Let's open that to public comment. If you have public comment on that issue.
Morning, Commissioners. Jim Wright again. I echo Commissioner Yao's concern about presenting the decisions that are made. What's interesting to me.
Chairman, I'm sorry, Mr. Wright. I think it's out of order for him to, unless you're speaking on the tabling motion, he's not going to the original motion. Just procedurally, I think.
Let's just
but I don't know if you want to do that.
Misunderstanding. Do you wish me to proceed or not?
Please continue.
Okay. As a citizen, it is important to me to understand the decisions that you have made. It's not important to understand what discussion has occurred up to those decisions or on other matters. So if your minutes were to reflect only the decisions, that would be enough for me. Thank you.
Thank you for your comment. Any panel discussion? Okay, all in favor of tabling the original motion until after subcommittee presentations, raise your hand and say yes. Yes? Yes. Okay, all opposed? Any abstentions? Okay. I apologize to the Commission. I've kind of let the agenda get away from me. We'll tighten that up and push through on the second half. I'd like to propose that we go ahead and break early for lunch and return back at 12:45. Great, let's do that. We're adjourned. We're noticed till 6:30 tonight, but close till we finish business today. So we might move that forward a little bit, but the agenda keeps us here till 6:30 at the latest. Thank you, sir.